think we're good.
Okay.
All right, so our group is looking at education law, and we decided since it's so broad to look specifically at like IEPs and how they're in the law. So it's going to be me, Jen, Sarah, and Andrea. So just as an introduction, IEPs are under IDEA, which is the Individuals with Disabilities Act. Their IEPs are like meant to protect children with disabilities as well as their parents and like overall just their right to education. And not only just an education, but a free, appropriate public education in the least restrictive environment. So the most recent IDEA Act that was enacted was in 2004, and they also put in protections for students of color, where they specifically are looking at disproportionality in representation within IEPs. So it's important just considering that like students of color are often overrepresented in special education. Yeah, so it's important considering that before the IDEA was enacted back in like 1975, children with disabilities were just turned away from education in general, and just had no opportunity for education. So not only that, but then like the least restrictive environment, like I was talking about, children with disabilities now are more generally in general education settings as opposed to being separated from general education students. And not only that, but they're also typically learning in like their neighborhood public education schools. Whereas before that, like I said, they were either turned away or completely separated from the general population. So not only that, but overall, after passing or enacting the IDEA, it increased educational opportunities for children with disabilities, whereas now in like from 1975 to 2007, it went from 30% of children with disabilities getting their high school diploma to 60%. And now almost half of children with disabilities tend to enroll in higher education as well. So it just overall opened up educational opportunities for kids with disabilities.
All right, so this is a video that's explaining IEP versus a 504. You can obviously watch it, Ashley, if you want to, but we actually intended to show this in class as it's just a good video to differentiate the two. So moving on to the next slide. This is the main case that our group decided to focus on. So this case is Andrew F. versus Douglas County, and it's involving an autistic boy named Andrew, his parents, and then the Douglas County School District. So the plaintiff in the case was Andrew, and he was receiving special education services from preschool through fourth grade through an IEP. When he was in fourth grade, his parents believed he was not making progress towards his goals. And so then in fifth grade, the special education team proposed a fifth IEP, and this is when Andrew's parents removed him from school and enrolled him in Firefly, which is a special program that provides special supports for children with autism. So the results of this case, and Sarah is going to actually jump into if I miss anything because both of us wrote our papers specifically on this case. So Andrew's parents filed a complaint under the IDEA with the Colorado Department of Education because Douglas County School District denied their request for reimbursement for the tuition at Firefly. So the case made it all the way to the Supreme Court. It was argued during the 2016 term. It came to the United States Court of Appeals for the 10th Circuit through, I'm going to pronounce this wrong, but it's writ of certiorari, which I know we've talked about in class before. And then through that, in a unanimous opinion was made by the judge that overturned the judgment of the 10th Circuit of 10th Circuit Court of Appeals, noting that the IDEA requires schools to apply a higher standard regarding special education services. So as I said, the court overturned the 10th Circuit's decision that Andrew was only entitled to an educational program that was calculated to provide merely more than de minimis educational benefit. And then in rejecting that, the Supreme Court determined that to meet its substantive obligation under the IDEA, a school must offer an IEP that is reasonable, calculated to enable a child to make progress year after year, despite their circumstances. So since then, there's been 49 cases that were decided by a judge who cited Andrew F. in the opinions. And then of the 49 cases, 44 of them saw no change. And in 37 of those cases, the decision was for the school district. In 2 cases, the case was sent back for further evaluation. And then 3 of the cases, the decision was reversed. So one of the people that spoke to this case was a special education director in Springfield, Missouri. And Sarah's going to talk about this later too, but the Andrew F. didn't really result in a major shift in the way that that like special education teams are doing business. And so the case offered a chance to make sure that the school professionals were collaborating with the parents and are collaborating with the parents, and that they're creating like these academic standards that these children can meet. And also just like brought to light the importance of parent input when creating IEPs. So that is the summary of the case.
So looking at analyzing the legal context of this case and IEPs in the law, it both works to protect and fails to protect the rights of historically marginalized and oppressed groups. So for example, like after Brown v. Board was passed and schools were desegregated, it kind of children of color were pretty commonly then put into the special education classes to continue the segregation in the schools. So that obviously is an example of how it fails to protect their rights. And then a way that it does protect their rights, like I was talking about earlier with the IDEA that was passed in 2004, they recognize the overrepresentation of students of color in special education, and they then put in protections against that, looking at disproportionality as a whole. And they have like things that they then do if disproportionality is seen in the special education system.
Yeah, so then another case going off of that was quoted a lot or cited a lot in Andrew F. case is the Rowley case of 1982, and that kind of came up with 2 parts. The first question is asking is, has the school complied to IDEA, and is the child receiving educational benefits? And at first, that was kind of just the minimus that we talked about, educational benefits. And in the Andrew F. case, that became a little more questioning, are these educational benefits actually, is this challenging the child? Are the goals challenging the child in a developmentally appropriate way that does challenge him or her, but also recognizes their disability? The important part of that Andrea was talking about, kind of the idea of collaborating with parents, and part of what was decided that was really missed in Andrew F's case is that even though they may have had goals for him that were stated in the IEP, those goals were not communicated to the parents adequately, and the progress was not communicated. So the parents, it kind of came as a shock to them that like it seemed to them that he was regressing, even though the school said they had made these goals. So I think they cited the case law of Rowley a lot when looking at that, is what are these educational benefits, and are they fitting for what NJUF needs? And that was part of the reason that that case was, or the 10th Circuit was overturned in that. So Andrea talked about the Director of Special Education in Missouri. And I think that's one thing that we hope did come from this case, was a little bit more of the collaboration. I think that is true that the collaboration came, but that does not really take into account how knowledgeable the parents are on education law and on what their child really needs, even on their child's disabilities, and how available the parent is to meet and come into these meetings. Those things were awesome and came from NJUF case, but that's because his parents were really involved and did have to just go right past that and say, well, he has goals, he was meeting them, or he wasn't meeting them. Yeah, so then moving on to the next slide, just a little more analysis. Kind of what Andrea and Jen both saying, the decision was unanimous, which is a big deal, but no tangible change came because no actionable steps were put in, and I was still kind of left on the schools and the school districts, and as we know, they're very underfunded and have a lot going on. The other thing that I was thinking about this is, as Andrea said, Andrew ended up going to Firefly, and what it doesn't talk about is how does IDEA affect and IEPs affect financing private schooling and also transportation to that schooling. So for example, there was a case law in 2008 that was Thompson R2 versus the National School Board Association, where a child had a disability and basically they made him pay for this, the family pay for this very expensive private school, and it did not go through that. The district ended up having to pay for it. So I think it's little aspects like that, that even though the NJUF case showed that, oh, in this IEP, we have to be doing more than de minimis, how is that actually going to happen? And how is that accessible and possible for the family?
Can I jump in real quick, Sarah?
Yeah, of course.
So we actually had a case earlier this year where there was an outside evaluation that was done by our school psych in our special education team about a girl who attended a private school that was in our area, but private schools don't fund 504s or IEPs. So basically, this child actually did need some accommodations and would very much so benefit from an IEP. But at the very end of the day, we could only offer these suggestions to this family and to like the learning specialist at the private school to kind of work with the teacher about some certain things. So to play off of what you just said, like the IEPs and the 504s are not like funded at these private schools. So sometimes they ask for like outside evaluators, such as like the public school special ed teams.
Yeah, that's an awesome example. And I think I'll jump down just because it relates to, we have a similar case at the school that I work for, which is Denver Academy, which is a private school, but is also all for students with diagnosed learning disabilities. And it's the same issue, is that, for example, we have one student that Cherry Creek does in fact pay for the child.
Oh, wow.
Tuition, which is awesome, but it doesn't pay for her transportation, and it's a single mom and the parents have a lot of trouble getting her there. They sometimes have a ride that picks her up, but if she misses it by like 5 minutes, which happens pretty much every day,
Right.
her mom still has to come and pick her up. So it's awesome that they fund that, but it's not really thinking practically about, okay, but how is this child, right? This mom has 4 other kids. How is this child actually going to get to school?
Right.
And this particular child does a half day because she can't really handle a full day. So what's going to happen? Who's going to pick her up? Her mom's at work. If she misses her ride, and the ride's very stringent, like if she gets there at 12:35, it's usually already left. So just thinking about kind of the pros and cons and what does it take? It's great to say in the law, but what does it tangibly take to put this into action? Going off of that, I just want to mention really quickly that I also looked at a case that was Fry versus Napoleon, which was a very recent case in 2017. And well, it started in 2017, and it also looked at, is IDEA, we talked about, and the video showed a little bit, if you watch the video, about the difference between IEP and 504. And 504s is under ADA, for disability, so it's section 504 of ADA. And kind of, do those ever get in the way of each other? So if a child, in the example of Fry versus Napoleon, it was a girl who had been prescribed a service dog to be with her everywhere. She had cerebral palsy, and the school was saying that that was not part of her IEP, and they hadn't exhausted all of the other IEP options before bringing the dog to school. So they actually would not let her bring the dog to school. And that also went all the way up to the Supreme Court. Don't have time to get into it, but just the idea of how do sometimes these laws actually get in each other's ways if it's not very clear kind of what's coming first. So your ADA benefits and your section 504, does that apply before your IEP, or do you have to exhaust everything in your IEP first? And I think that all just goes back to, this was a really huge win. Andrew F. really was. Intangibly, it absolutely was, but tangibly, kind of how much of a difference is it actually making?
Right.
Yeah. I don't know if anyone wants to add anything else to that.
No, I think definitely work. I mean, I'm not sure, Sarah, how private schools work with special education and like, but I know within the public school sector, we have a long ways to go, I think, with providing children just what they need, whether it be like, integrated within the classroom or pulling them out for certain things. And then also, I think it's really important when, since a lot of us in class want to do school social work, just being able to like have realistic goals for the kids that we work with, and just obviously what we talked about through the whole presentation, kind of just communicating that with the parent and being as transparent as possible.
Yeah, so I think that's kind of, this kind of case is kind of, it is a win, and it also is showing us how far we have to go and how we can take these ideas that maybe have been said in a unanimous decision in court, but how do we actually make those happen? How do we make them actionable for students?
All right. Well, I think that's all we have. Ashley, we'll go ahead and send you the PowerPoint, and then obviously send you this recording, and hopefully all the technology will work. All right.